A man takes the stand in 4th District Court. He is the chief medical examiner for the state of Utah. He has been called by the prosecution, not the defense. And under questioning, he tells the jury something that should have ended the case. He could not certify the death as a homicide. He did not have enough. 9 days later, that same jury convicted Martin MacNeill of murdering his wife. Both of those things are true. They sat in the same courtroom in front of the same 12 people, and the jury still went one way. This documentary is about the space between them, because that space is where the actual lesson of this case lives, not in the drama, in the reasoning. Michelle McNeel died on the morning of April 11, 2007, in her home in Pleasant Grove, Utah. She was 50. She was recovering from facial surgery she'd had 8 days earlier. She had 8 children, 4 of them adopted from Ukraine. Her death was ruled natural. There was no crime scene because nobody thought there had been a crime. 6.5 years later, her husband was convicted of first-degree murder on a death certificate that still to this day lists her manner of death as undetermined. How does that happen? And more importantly, should it? Start with the version of April 11th that nobody disputed at the time. Martin MacNeill was, on paper, one of the most credentialed men in his community. A physician, also an attorney, the clinical director of the Utah State Developmental Center in American Fork, a state-run residential facility for people with disabilities, a former bishop in his local congregation of the Church of Jesus Christ of Latter-day Saints. Father of 8. That morning, he picked up his youngest daughter, 6 years old, from kindergarten. They came home. The girl called out for her mother and got no answer. She followed her father into the bathroom, and she found Michelle in the tub, still dressed. Her father sent her next door for help. Neighbors came. Michelle was lifted from the tub. Emergency responders arrived, took over resuscitation efforts, and she was transported to a hospital in American Fork, where she was pronounced dead. Here is where the case was quietly decided for the next 3 years. The emergency room physician could not determine why a 50-year-old woman had died, so he did the correct thing and called the medical examiner's office. An autopsy was performed by Dr. Maureen Fricka, an assistant state medical examiner. Days later, she spoke with Martin MacNeill directly. He described how he had found his wife, slumped forward over the rim of the tub, her face submerged, her lower body hanging outside it. Dr. Fricka ruled the manner of death natural. Cause: cardiovascular disease, with high blood pressure and inflammation of the heart. And on the information available to her, that ruling was reasonable. That's the part most coverage of this case skips past, and it matters. A woman in her 50s with documented high blood pressure, 8 days out from a long surgical procedure, with prescription medications in the home, found unresponsive in a bathtub. That is not an exotic scenario. It is one of the most ordinary ways a sudden death presents in any medical examiner's office in the country. The forensic term for the trap here is anchoring. When a case fits a familiar shape, the familiar shape stops being a hypothesis and starts being the frame. Everything after that gets read as confirmation. Nobody in that system was careless. The system simply did what systems do. It recognized a pattern. Death investigation is not one investigation. It's 2. One is performed on the body. The other is performed in the room. The position, the water level, the towels, the clothing, what responders saw and heard, what everyone in the house said in the first hour. A medical examiner's conclusion is a synthesis of both. Take away the second half, and the ruling doesn't become uncertain. It becomes confident and wrong, with no signal that anything is missing. In Pleasant Grove, in April 2007, the second investigation never happened, because the death wasn't suspicious, because nobody had suggested it should be. Consider one fact. When paramedics performed CPR, Michelle expelled a substantial volume of fluid from her mouth, reported later as multiple cups, more than once. To a forensic pathologist, that is not a detail. It is one of the few observable indicators that a person may have taken water into the airway and stomach while still alive. Dr. Fricke did not have that information when she signed the ruling. It surfaced roughly a year later through interviews conducted by people who had gone looking. By then, she had died of cancer and could never be asked what she would have concluded with a fuller picture. That is the most transferable lesson in the file, and it has nothing to do with Martin MacNeill. A medical examiner's finding is only as good as the narrative handed to them, and in a home death, that narrative is very often supplied by the last person who was there. The autopsy is not an independent check on that account. It is downstream of it. The reopening of Michelle's death didn't begin with forensic science. It began with a background check. Michelle's adult daughters, Alexis, then in graduate school for medicine, and Rachel, along with Michelle's sister, went to investigators and asked them to look again. What investigators found was not evidence of murder. It was a resume that didn't survive contact with a record search. Court records and reporting from the period establish a documented pattern. Martin MacNeill had felony convictions in California in 1978, months after he and Michelle married. He later admitted to falsifying academic transcripts to gain admission to medical school and to misrepresenting his record on a law school application. He had been sanctioned in a Medicaid fraud matter. He had, at various points, represented himself to the Department of Veterans Affairs as psychiatrically unable to work or study, while holding a medical license, a law degree, and the clinical directorship of a state institution. None of that is proof of homicide. It is, however, proof of something else, and the something else is uncomfortable. Every institution that was supposed to catch this man had already looked at him and approved. 2 medical schools, a licensing board, a law school, a state agency responsible for vulnerable adults, a federal benefit system. Credentialing systems verify documents. They rarely verify people, and they almost never talk to each other. A forged transcript, once accepted, becomes a real one, because the next institution in the chain checks the credential, not its origin. That isn't a Utah problem. It's how professional gatekeeping works nearly everywhere. In 2009, he pleaded guilty in federal court to charges connected to identity theft involving one of his adopted daughters, and was sentenced to 4 years. He pleaded guilty to fraud-related felonies in state court as well. His medical license was surrendered. By the time Utah County prosecutors charged him with murder in August 2012, weeks after his release from a federal facility in Texas, he was already, in the public record, a documented fabricator, which created its own problem. A jury has to be told, very carefully, that a liar is not automatically a killer. Everything the prosecution eventually built rested on a 4-week window in the spring of 2007. According to trial testimony and the appellate record, Michelle had grown suspicious that her husband was involved with another woman. She checked his phone records. She confronted him. He told her she was being ridiculous. Shortly after that confrontation, he presented her with facial cosmetic surgery as a gift and floated a 2-week cruise afterward. Michelle was hesitant, not opposed, but hesitant. She wanted her blood pressure under control first. A primary care physician evaluated her, found her otherwise in excellent health, and suggested she postpone the procedure until the hypertension was managed. Her EKG was normal. That recommendation was not passed along to the surgeon. At the preoperative appointment, Michelle said in the car that she wanted to push the surgery to summer. Her husband, according to Alexis's testimony, became angry and told her that if she didn't do it now, she wasn't doing it at all. Then came the detail that prosecutors would return to again and again. Before that appointment, Alexis saw her father in his bedroom writing out a list of medications from a reference book she hadn't seen him touch in a decade or more. At the consultation, he did most of the talking. Working from his list, he requested 4 departures from the surgeon's standard post-operative regimen. an additional, stronger opioid, a liquid formulation of another pain medication, a larger quantity of an anti-nausea drug in suppository form, and a sedative from the benzodiazepine class. He framed it as wanting options available. The surgeon, deferring by his own later account to a fellow physician, wrote them and told Michelle plainly to take one at a time and not to combine them. Michelle told him she intended to take as little as possible. That sentence is load-bearing, because when investigators later looked at the toxicology from her autopsy, they found 4 substances in her blood: an opioid, a benzodiazepine, an anti-nausea medication, and a sleep aid. At levels a consulting toxicologist described as sufficient to leave her profoundly sedated and difficult to rouse. The prosecution's argument was not that those drugs were exotic. It was that they were in the wrong person. A woman who disliked medication, who had been tapering off, who had walked around the house the day before and made plans to pick her children up from school, was found with a combination in her system that she had specifically told 2 doctors she didn't want. The defense's answer was straightforward and not unreasonable. Patients in pain take more than they say they will. People misjudge doses. It happens constantly, and it kills people who never intended to die. There is no forensic test that resolves that disagreement. Toxicology tells you what was in a body. It does not tell you whose hand it came from. Most murder cases that involve premeditation show a defendant arranging to be somewhere else. What prosecutors described in this case was stranger, and I think it's the most analytically interesting element of the entire file. In the weeks before his wife's surgery, Martin MacNeill began telling people he was seriously ill. At church, during an emotional lesson, he announced he had cancer and less than a year to live. He began limping. He used a cane. He wore a surgical boot. But the illness he described changed depending on the audience. One colleague heard about a nerve problem in his toe. Another heard cancer in the toe. Another heard something resembling multiple sclerosis. During the same period, he was renovating his own basement, carrying full sheets of drywall down the stairs without apparent difficulty. At his wife's funeral, witnesses described him setting up beforehand, moving quickly between his car and the church without the cane, and then beginning to limp as mourners arrived. Prosecutors read this as construction, not an alibi for absence, an alibi for incapacity. A man building in advance and in front of witnesses an explanation for why he would not have been physically able to lift his wife out of a bathtub. The defense's response is worth studying. Rather than fight that framing, they leaned into the physics, calling an ergonomics expert who testified that lifting a woman of Michelle's size out of a high-rimmed tub, bent at the waist, would have exceeded safe limits for a man of the defendant's build. Rational, and arguably a gift to the prosecution, because it accepted the premise that the lift was the crux, and jurors had already spent weeks hearing that his frailty was theatrical. Then there is the photograph. On the morning of April 11th, Martin MacNeill was to receive an award at work. According to testimony, he told the event coordinator insistently that he needed to be photographed. After the ceremony, he pressed the photographer twice to confirm he was in the shot, and suggested a second picture be taken to be sure. He picked his daughter up from kindergarten at 11:30. You can read that as an anxious man wanting a keepsake on a proud morning. Or you can read it as a man documenting his own location. The jury was allowed to choose. That is what circumstantial evidence is, a set of facts that are individually explainable and cumulatively difficult. Without Alexis Summers and Rachel MacNeill, there is no prosecution. That's not sentiment. It's the procedural record. Utah County did not begin investigating until 2008, and it began because family members arrived with material they had assembled themselves. They pushed, they documented, they wrote to officials, they kept alive a case the state had already closed. This is where most retellings stop, because it's the satisfying version, the The full version is harder and more useful. The family's investigation also damaged part of the evidence. The youngest daughter, the child who found her mother, was interviewed at a children's justice center in 2008 properly by trained personnel. Afterward, state investigators asked Alexis to put follow-up questions to the girl, and she did. At trial, Judge Derek Pullen ruled the child not competent to testify. His finding was blunt. After the formal interview, she had been subjected to suggestive, repeated questioning about material facts by an untrained interviewer with a bias about guilt and a personal interest in the outcome. The court found a substantial likelihood that false memories had been implanted or real ones distorted. He did admit the original Children's Justice Center interview because it predated that questioning and was corroborated by other witnesses, but the live testimony of the only other person in that house was gone. This is not a criticism of a grieving daughter. It's a demonstration of something forensic psychologists have understood for decades, and the public still resists. Memory is reconstructive, not recorded, and it is exquisitely vulnerable to repetition and expectation, especially in children, especially when the questioner is someone the child loves. Sincerity is not a safeguard. It's a risk factor. The family rescued the case. The family also compromised a witness. An honest account has to hold both. The prosecution called 5 jailhouse informants, 4 federal inmates who had served time with McNeill before he was charged, and 1 who knew him from the Utah County Jail. 2 testified to explicit admissions. 3 testified to remarks that stopped just short. Variations on the theme that the authorities couldn't prove anything. Jurors are not naive about informants, and the trial court gave what the appellate court later called an exemplary instruction. A witness who believes cooperation may buy his freedom has a motive to lie, and his testimony must be weighed with great care. But the issue here went further than motive. It went to conduct by the state. Before trial, prosecutors filed a formal notice stating that the 4 federal inmates had requested nothing and been promised nothing. During trial, the defense produced recorded calls and correspondence showing that the lead investigator had told one of them he wanted to get him out early, had described him as a key witness, and had said he preferred phone over email so the defense wouldn't learn of their contact. That inmate had told family he expected to be home by Christmas. 1 week after the trial ended, the investigator wrote to the U.S. Attorney's Office recommending leniency. The inmate was released that December. Judge Pullen examined this in a 40-page ruling and did not soften it. He found the state had suppressed exculpatory impeachment evidence. He wrote that the investigators' claim to have simply forgotten under direct questioning tested the bounds of credulity. He noted that the state's attempt to minimize that witness's importance rang hollow, and then he denied the motion for a new trial. Here is the legal standard that non-lawyers almost never hear, and it explains more American appellate outcomes than any other rule. Under Brady v. Maryland and Giglio v. United States, suppression of favorable evidence violates due process only if that evidence is material, meaning there is a reasonable probability the outcome would have been different. If the withheld material is merely cumulative of impeachment the jury already heard, it isn't material. The court's reasoning was that defense counsel had already exposed this witness for what he was, a calculating man who would say what he needed to say to get out. The judge called that cross-examination long, pointed, and devastating. So the ruling wasn't that the state behaved acceptably. It was that the jury had already been given enough to distrust the witness and distrusted him anyway, and convicted anyway. The Utah Court of Appeals affirmed that analysis in March 2017. It also pointed out something the defense brief had avoided. The argument that the informants were the only evidence of homicide simply wasn't accurate on the record. It's worth being precise about what was proven and what wasn't, because this case is frequently described as if science convicted Martin McNeill. It didn't. The state's own chief medical examiner told the jury he could not diagnose drowning and could not certify homicide. He did testify that drug toxicity played a role and that drowning remained possible, noting the fluid Michelle expelled during resuscitation. A forensic pathologist retained by the prosecution went further and concluded she had drowned, citing heavy lungs, fluid in the airway, and diluted blood. A cardiologist testified the heart inflammation in the original autopsy was mild, not enough to present a significant risk of cardiac death. The defense answered with the simplest possible story. A woman with a documented heart condition had a cardiac event and ended up in the tub. There was, their attorney argued, simply no proof of homicide. So the jury was handed a scientific stalemate and asked to resolve it with behavior. Not the drugs, the conduct. A 911 call in which he gave a wrong address and hung up repeatedly. An account of his wife's position in the tub that didn't match what neighbors saw when they walked in. Neighbors who described him leaning over her without observing his mouth make contact during rescue breaths and without her chest rising. A bedroom stripped of medical equipment by that evening. A daughter's medication log missing. Pills counted and then flushed. 30 text messages and 2 calls with the woman he'd been seeing on the day his wife died. And 9 days after the funeral, that same woman moving into the family home as a nanny under a different first name. A woman who, testimony established, never actually functioned as a nanny. The Utah Court of Appeals stated the governing doctrine plainly: circumstantial evidence alone can establish guilt, and a mosaic of circumstances taken as a whole can constitute proof beyond a reasonable doubt. Direct evidence is not required. That is settled law in every American jurisdiction. It is also the part of the law that makes thoughtful people uneasy, and it should, because the same doctrine that convicted Martin McNeill has, in other cases, convicted people who were later exonerated. The jury deliberated 11 hours and returned a verdict just after 1 a.m. on November 9, 2013. Guilty of first-degree murder and guilty of obstruction of justice. In July 2014, in a separate proceeding, a jury convicted McNeill of forcible sexual abuse involving his adult daughter in an incident weeks after Michelle's death. He was sentenced that September to 1 to 15 years. Days later, Judge Pullen sentenced him on the murder and obstruction convictions, 15 years to life, plus 1 to 15, ordered to run consecutively to the abuse sentence, a minimum of 17 years before parole eligibility. The judge described a man living a double life who was unwilling to surrender either half of it. The family that had spent 7 years pushing stood up and spoke. Alexis Summers told the court her father had destroyed her world. There is one more casualty in this record that rarely gets mentioned. Michelle and Martin's only son, Damien, died in January 2010 of a prescription drug overdose. In the middle of the years his sister spent fighting to reopen their mother's case. Families do not survive these investigations intact. That is worth saying out loud in a genre that tends to end at the verdict. On March 16, 2017, the Utah Court of Appeals affirmed the conviction. 3.5 weeks later, on April 9th, Martin McNeill was found dead at the Utah State Prison. Investigators later ruled it a suicide. He had attempted to take his own life once before, weeks after the murder verdict. He never acknowledged responsibility. Strip away the cable news framing, and 3 durable lessons remain. First, the most dangerous moment in a suspicious death is the first hour, and it usually passes without anyone noticing. This case wasn't solved by better science in 2013. The science in 2013 was inconclusive. It was reopened because people who knew Michelle refused to accept a paperwork answer. Nearly everything the prosecution eventually used existed on April 11, 2007. It simply wasn't collected because nothing had flagged the death as worth collecting. Second, Credentials are a form of evidence, and they're weaker than they look. Every institution that certified this man had checked a document. None had checked the person. When someone occupies enough respected roles, those roles start doing the work that scrutiny should be doing. For licensing boards, for neighbors, and for 3 years, for a death investigation. Third, a conviction is not the same thing as a clean process. The trial judge found that the state suppressed evidence and that its lead investigator's explanation was not believable, then upheld the verdict under a materiality standard that is correct as law and still leaves a residue. You can believe the jury reached the right conclusion and believe the state should not have behaved that way. Holding both is what informed observation of the justice system actually looks like, and the final irony sits right there on the paperwork. The man was convicted of murder. The document recording how his wife died still says undetermined. A jury answered a question that forensic medicine never could, using the one category of evidence that no laboratory can process. What a person does in the hours after a tragedy. If the state's own medical examiner told the jury he could not call this a homicide, was a behavioral case enough to convict beyond a reasonable doubt? Or does this verdict rest on a standard that should make us uncomfortable? Let us know how you see it. Cases like this remind us that some questions continue long after the headlines fade. If you found this documentary informative, consider subscribing for more carefully researched true crime stories. We'd also love to hear your thoughts in the comments below. Thank you for watching, and we'll see you in the next documentary.